So, we've got a major new development coming out of the nation's highest court that could reshape how federal agencies operate across the entire country, affecting virtually every American in ways most people don't even realize yet. This all comes out of a case that started as a relatively obscure dispute over regulatory authority, but has now exploded into a landmark ruling, with the Supreme Court issuing a rare 9-0 unanimous decision that completely transforms the legal landscape for administrative law, and now federal agencies are scrambling to figure out what this means for thousands of existing regulations, while legal experts are calling this one of the most significant constraints on federal power in decades. So let's break down what is happening in this critical case and why it matters for your daily life in ways you probably haven't considered. Now, before we jump into the details, if you want to support this type of in-depth legal analysis, one of the best ways to do that is simply to engage with the content. Also, I want to thank one of the main supporters of this channel, which is a legal services organization that helps people navigate complex regulatory and self-defense issues. When it comes to protecting yourself from government overreach and understanding your rights, in my opinion, this organization is in a league of their own. They're backed by actual attorneys who specialize in constitutional and regulatory law, and they're always trying to give you as much educational value as possible as a member. They've expanded their coverage to include things like regulatory compliance assistance, civil liability protection, administrative hearing representation, and a lot more that they're always adding. So if you're interested, if you want to check them out, you can do so using the links down below. And if you use my code, you can get a discount off your sign-up fee. So if you've been following legal news for a while, you know that the Supreme Court recently issued this stunning 9-0 unanimous ruling in a case called Corner Post Inc. versus Board of Governors of the Federal Reserve System. Now, this might sound like some dry banking regulation dispute, but trust me, this is anything but boring. This case has the potential to upend decades of established administrative law and could open the floodgates for challenges to everything from environmental regulations to healthcare rules to financial oversight. Essentially, back in 2021, a North Dakota truck stop and convenience store called Corner Post filed a lawsuit challenging a Federal Reserve regulation that set the maximum fees that banks could charge for debit card transactions. But here's where it gets interesting. This regulation wasn't some new rule that just came out. It had been finalized back in 2011, more than a decade before Corner Post even opened its doors for business. Now, when this happened, most legal observers assumed the case would get thrown out immediately on procedural grounds. After all, there's this long-standing legal principle that there's a 6-year statute of limitations for challenging federal regulations under the Administrative Procedure Act. Everyone thought Corner Post was too late, that they had missed their window to sue, and that would be the end of it. The Federal Reserve certainly thought so, and so did the lower courts that initially dismissed the case. But Corner Post had a clever and, as it turns out, legally brilliant argument. They contended that the statute of limitations shouldn't start running when the government issues a regulation, but rather when a party is first actually harmed by that regulation. Since Corner Post didn't exist as a business until 2018 and didn't start accepting debit cards until 2019, they argued they couldn't possibly have challenged the 2011 rule any earlier because they weren't even around to be affected by it. So, essentially, they were saying, look, we didn't miss the deadline because the clock never started ticking for us. The harm didn't occur when the government wrote this rule 10 years ago. The harm occurred when we opened our business and started getting hit with these fees that the regulation allowed. This argument was clever because it exploited a genuine ambiguity in the law about when exactly the statute of limitations begins to run for regulatory challenges. The Federal Reserve and the Biden administration pushed back hard, arguing that allowing this interpretation would create chaos. They warned that if every new business could challenge old regulations just by claiming they weren't around when the rules were first issued, it would destabilize the entire regulatory framework. They said it would undermine the finality of agency actions and subject decades-old regulations to constant new litigation from newly formed entities. But Corner Post countered that the whole point of the Administrative Procedure Act was to provide meaningful judicial review for those actually affected by government action. They argued that it would be absurd to say a business that didn't exist in 2011 had somehow forfeited its right to challenge a regulation it had never encountered and couldn't possibly have known about. They pointed out that the statutory text says a claim accrues when the cause of action accrues, which traditionally in American law means when the injury actually occurs, not when the government announces a policy. So they went to court, and initially things didn't go their way. The district court sided with the Federal Reserve, dismissing the case as untimely. The Eighth Circuit Court of Appeals agreed, holding that the statute of limitations began to run when the regulation was first promulgated in 2011, regardless of when any particular plaintiff came into existence or started being affected by it. This case eventually made its way to the Supreme Court, and legal observers were deeply divided on what would happen. The Biden administration filed briefs warning of dire consequences for regulatory stability. Industry groups lined up on both sides. Some saw this as a weapon to dismantle the administrative state, while others feared the uncertainty it would create. Many expected a closely divided court, perhaps a 5-4 decision with the usual ideological splits. But when the decision came down, it wasn't close at all. The Supreme Court ruled in a 9-0 unanimous decision in favor of corner post. Now, Justice Amy Coney Barrett, writing for the majority, stated that the plain text of the Administrative Procedure Act was clear. A cause of action accrues when the plaintiff has the right to bring it, and that right only exists when there's an actual injury. She rejected the government's argument that regulatory finality should trump individual rights, noting that the whole purpose of the APA was to allow those aggrieved by agency action to seek judicial review. The court held that the 6-year clock starts ticking when a party is first injured by a regulation, not when the regulation is first issued. This means that a business formed yesterday can challenge a regulation issued 30 years ago if that regulation first starts affecting them today. Justice Barrett emphasized that this wasn't some novel interpretation, but the standard application of accrual principles that apply throughout American law. She pointed out that it would be bizarre to hold that someone who didn't exist in 2011 had somehow slept on their rights by not suing in 2011. The government had argued that this would create endless uncertainty, but Barrett responded that this was simply the cost of ensuring meaningful access to courts for those actually harmed by government action. She noted that Congress could have written the statute differently if it wanted to prioritize regulatory finality over individual rights, but it didn't. Now, Justice Ketanji Brown Jackson wrote a separate concurring opinion, joined by Justices Sotomayor and Kagan, agreeing with the result but emphasizing that this decision didn't necessarily open the door to every imaginable challenge. She noted that other doctrines like issue preclusion and claim preclusion might still prevent some repetitive litigation, and that courts would need to be careful about how they applied this principle in practice. But she didn't dissent. She agreed that the statutory text compelled this result. So it was 9-0. Even the liberal justices who might be sympathetic to regulatory goals couldn't find a way around the plain language that Barrett identified. Now, here's where this case currently stands and why it's causing such an earthquake across Washington. After the Supreme Court issued this ruling, federal agencies immediately went into crisis mode. The Department of Justice, which defends agencies in court, reportedly held emergency meetings to assess the vulnerability of existing regulations. Regulatory lawyers are now gaming out scenarios where every major rule from the last several decades could face new challenges from newly formed businesses, newly organized nonprofits, or even individuals who just turned 18 and can now claim they weren't around to challenge older regulations. The ruling applies to any regulation issued by any federal agency, which means we're talking about Environmental Protection Agency rules on clean air and water, Department of Labor regulations on wages and workplace safety, Food and Drug Administration approvals and restrictions, Federal Communications Commission rules on media ownership, and thousands of other areas of federal oversight. The implications are staggering. Consider a small business that opens next year in 2026. Under this ruling, that business could challenge a Clean Air Act regulation issued in 1990 if that regulation affects their operations. They could challenge a Federal Communications Commission media ownership rule from 2002 if they want to start a broadcasting company. They could challenge a Department of Education student loan regulation from 2010 if they open a vocational school. The 6-year window now moves with the plaintiff, not with the government action. This completely inverts the previous understanding of regulatory finality. For decades, agencies and regulated industries operated under the assumption that once 6 years passed after a rule was issued, that rule was effectively immune from facial challenges. That certainty is now gone. The Corner Post decision also intersects with another major Supreme Court ruling from last year that overturned the Chevron deference doctrine, which had required courts to defer to agency interpretations of ambiguous statutes. Combined, these two rulings create a pincer movement against the administrative state. First, Chevron's fall means courts no longer automatically defer to agency expertise when interpreting statutes. Now, Corner Post means that the pool of potential challengers to any regulation is essentially infinite because new parties can always come forward with fresh claims. A regulation that survived challenge in 2015 might face a completely new challenge in 2026 from a party that didn't exist in 2015, and courts will now have to review it without deferring to the agency's expertise. Legal scholars are already debating whether this combination of rulings amounts to a constitutional revolution in administrative law. Some are calling it the end of the New Deal settlement that empowered federal agencies to manage complex modern economies. Others argue it's a necessary correction that restores judicial oversight and individual rights against unaccountable bureaucracy. But regardless of where you stand on the policy, the practical impact is undeniable. Federal agencies are now facing the prospect of defending decades of regulatory accumulation against potentially endless waves of new litigation. Every major rule is now a permanent target, never safe from challenge as long as new businesses keep forming and new individuals keep coming of age. The Biden administration and regulatory advocates have warned that this will paralyze agency action. They argue that if agencies know their rules can be challenged forever by newly emerging parties, they might be reluctant to issue necessary regulations in the first place. They point out that this gives a massive advantage to well-funded industry groups who can simply spin up new corporate entities specifically designed to challenge regulations they don't like. If a challenge fails, create a new subsidiary and try again with a fresh plaintiff. The 6-year window never closes because there's always a new plaintiff with a new injury date. They warn that this will lead to regulatory chaos, with courts having to constantly revisit old rules and agencies unable to plan for the future. But supporters of the ruling, including many in the business community and libertarian legal circles, argue that this is exactly how it should be. They contend that no regulation should ever be immune from challenge by those actually harmed by it. They point out that the previous system allowed agencies to entrench bad rules simply by running out the clock, preventing future generations from challenging outdated or harmful regulations. They note that technology changes, economic conditions evolve, and new business models emerge that couldn't have been anticipated when old rules were written. Why should a regulation written before the internet existed be permanently insulated from challenge by a tech startup that couldn't possibly have sued in 1995 because it didn't exist yet? They argue that this ruling restores the proper role of courts as a check on executive power and ensures that regulatory compliance is always subject to judicial review when actual harm occurs. Now, the immediate fallout is already visible. Within days of the Corner Post decision, new lawsuits were filed challenging long-standing regulations across multiple agencies. A new financial technology company incorporated in 2024 filed suit against a Consumer Financial Protection Bureau rule from 2013. A recently formed environmental group organized specifically to challenge EPA regulations sued over a clean water rule from 2015. A startup airline established in 2023 challenged Department of Transportation tarmac delay rules from 2009. These are test cases probing the boundaries of what Corner Post allows. Legal defense funds are reportedly raising millions to identify regulations that can now be challenged and to incorporate new plaintiffs specifically for that purpose. The Department of Justice is scrambling to develop litigation strategies to defend against this new wave. They're exploring arguments about claim preclusion, arguing that if a regulation was already upheld in earlier litigation, that should bar subsequent challenges even from new parties. They're looking at Article 3 standing requirements, trying to argue that some plaintiffs lack sufficient connection to the harm they're claiming. They're even considering asking Congress to amend the Administrative Procedure Act to restore some version of the old time limits, though in the current polarized political environment, legislative fixes seem unlikely. Meanwhile, agencies are reviewing their existing regulatory portfolios, trying to identify which rules are most vulnerable and whether they should proactively update regulations to reset the clock and address potential vulnerabilities. Now, this case is no longer just about a North Dakota truck stop and debit card fees. It's about whether the American regulatory system will operate under rules of finality and certainty, or whether it will become a permanent battlefield where no regulation is ever truly settled and every rule is subject to perpetual challenge by newly minted plaintiffs. The Supreme Court made clear that statutory text matters more than administrative convenience. The 6-year limitation period protects plaintiffs from stale claims, not agencies from accountability. Again, this was 9-0. Even justices who generally favor regulatory power couldn't find a way around the plane, meaning that Justice Barrett identified. So where does this currently leave us in this challenge? Well, now you have that 9-0 unanimous ruling by the court, transforming the landscape of administrative law. Federal agencies are reassessing their entire regulatory frameworks. Litigation funders are mobilizing to exploit this new avenue for challenge. Congress is facing pressure to respond, though action seems doubtful. And millions of Americans are going about their daily lives unaware that the rules governing everything from the air they breathe to the financial transactions they make are now newly vulnerable to legal challenge. This ruling doesn't just affect businesses, it affects consumers who benefit from or are protected by regulations. It affects workers whose safety rules might be challenged. It affects patients relying on drug approvals, homeowners depending on mortgage regulations, and virtually everyone who interacts with the modern economy. The 9-0 margin matters here. This isn't a polarized court dividing along ideological lines. This is the entire Supreme Court agreeing that the law says what it says, regardless of policy consequences. That makes it much harder for critics to dismiss this as partisan judging. It also makes it much harder to reverse, either through future litigation or legislative action. When the entire court aligns on statutory interpretation, that interpretation tends to stick. So as we move forward, the key questions will be how lower courts apply this principle, how agencies adapt their rulemaking processes, and whether Congress eventually steps in to clarify the statutory framework. Will we see a new era of regulatory volatility with rules constantly in flux as new plaintiffs emerge? Or will agencies and courts develop new doctrines to restore some stability while respecting the court's holding? Will this ruling primarily benefit well-funded industry groups who can manufacture plaintiffs, or will it genuinely open doors for small businesses and individuals previously shut out by time limits? These questions will play out over years of litigation and administrative practice. I will be monitoring these developments closely to see how agencies respond, what new challenges get filed, and how the lower courts handle the inevitable flood of corner post-inspired litigation. As we get more information, as it develops more, I will let you know. If you appreciate this type of detailed legal analysis that connects Supreme Court decisions to real-world impacts, one of the best ways to support this work is simply to like, comment, and subscribe. All of those things help to fuel the algorithm and just tells the system that you appreciate this type of content, and so it shares it with more people. But as always, thank you so much for all of your support, and never forget that understanding these legal developments is essential for maintaining informed citizenship in a complex regulatory democracy.